think this will be our last question. Waiting patiently, Richard. Richard actually came on last week. We had a question about the effect of tax step-ups and does the estate miss it if they don't take advantage of it during the probate process? And as I said, about 8 different ways. I'm not an attorney and can't give legal advice or tax advice. He actually researched an answer and he got some good advice for us on that topic. Hey, Richard, how you doing?
I'm great, Bill. Thanks. Yeah, I listened to last week's call after it was posted, and the question came up: does a step up in basis, is that triggered by the death of the decedent or the close of the probate case? And no one seemed to have an answer on that call. So I did some quick research, and the citation on that, even though I'm not an attorney, I'll give it to you, is Title 26 of the U.S. Code, Section 1014. So this is the Internal Revenue Code. And as I was thinking about it, logically, the tax code is entirely separate from whichever state you're operating in, the state probate code.
Correct.
So in a tax question, it's the Internal Revenue Code that's going to control. And that section 1014A1 says, except as otherwise provided, the basis of property in the hands of a person acquiring that property from a decedent is the fair market value of the property at the date of the decedent's death. It gets into a bunch of other special circumstances, but B1 goes even further and says that step up in basis applies to property acquired by bequest, devise, inheritance, or by the decedent's estate from the decedent.
Right.
So the estate automatically gets the step up in basis on the date of the decedent's death. It has nothing to do with, is there a probate case filed? Is it an open probate? Is it a closed probate? That's strictly that. And the other point is there are lots of situations where the probate law and probate court in your state wouldn't have any effect, wouldn't even be involved in case of a transfer for the terms of a living trust, if the property was titled in the name of that trust, a transfer on death deed if your state has those, a whole bunch of other situations that I referenced in my email to you in a conversation back and forth about that.
This was an answer to a question a family was considering: should they sell the property during probate or should they wait till after probate? And the answer was it doesn't really affect them as far as the step-up basis to avoid the taxes on the estate. And thank you for answering that. And then also the email you sent points out there's some exceptions where people try to deed on a family member to be able to control the estate before mom dies. And that can totally change the step-up basis, because now once you add the child on, that portion of the property doesn't go up in value, doesn't get the step up perhaps.
Right.
So definitely these are things that we want to consult with attorneys. What I said, and I did, for those on the call, I want to tell you, I took my own medicine, is I took the opportunity to call 2 different CPAs to ask them this question. More important than the right answer is the phone call to the accountants to remind them I'm a probate expert. If anybody needs help, to contact me. And they were flattered that I called them, and they respect that I had enough information to even ask a good question. So I would say all of you, if you want to get one more good contact in your probate business, call your local accountant and ask that person how they would handle that. Even though you have an answer from Richard, you can refer a client who asks you to the accountant. You may or may not want to refer them to Richard, but you might want to refer them to your accountant. So Richard, thank you for the research. I appreciate it.
Yeah, it's often wise to play dumb and ask an expert to start a conversation.
Exactly, because we want to be in relationship with those experts. We don't want to.
And you can ask them about the situation where it's usually someone who's not very sophisticated financially, is thinking that even though they might only own a house, that's the only sizable asset they've got, they think they're going to owe a boatload in estate taxes, or they're worried, or they've got 3 kids. The 2 older kids are married, have houses of their own, are doing okay financially. And Junior is kind of the black sheep, falling behind his siblings. And they say, well, I'm going to give Junior the house so that he has a house too, but I want to keep the property taxes the same for him because he doesn't have much income. So I'm going to put him on the deed. So now I've quit claimed half the house to him. That's a gift. And there are gift tax implications that have to be dealt with. But beyond that, the basis follows the gift at the time of the gift. You don't get the step up in basis. Junior won't get that on his half of the house. He might when mom or pop dies on the other half.
Look, this is all great material. And I always tell people, if you want to build your probate business, pick an area or a niche that excites you and interests you, learn about it, and then share what you learn with your clients, with your database. You don't need to just call new prospective families in probate, But if you already have a database of 300 past clients, friends, family, when you learn these things, share them within. True, of 300, very few will need to sell a house on probate. But if one or two did a month, you'd have a great business. And so that's where we want to be learning and become experts, be in the process of being an expert, not the destination of having been an expert. Richard, thank you very much for following up on that. I really appreciate your follow-up in the email and such.